Hello, my name is John Gardner, and I'm an attorney. What date are you responsible for? This is a special insurance industry presentation. The laws have changed. In fact, everything has changed when personal data is involved. And because information has become so important, this presentation may not be copied, trained from, or used in any capacity without the written permission of accurate data partners. Privacy and Security Law Report says that you only need to worry about privacy and security laws and rules if you have customers or employees. Well, that's all of us. Now, over the next few minutes, we're going to cover two basic things. What has changed the landscape and why it matters to you both personally and professionally, the new liabilities and the new opportunities across the insurance industry. And then number two, why are businesses generally being required to implement training and put new written policies in place? Let's answer those questions. To begin to explain the change in the landscape, you've got to take a complete approach to what we call the database view. Now, with any business, whether it's a medical office or an insurance company or agency, first you have to authenticate who your customer is and who your employees are. You got to make sure they are who they say they are. Second, as you take in their information, you've got to make sure their information is safe and secure. Then you've got to keep it private. You can only use information for its intended business purpose, not for other reasons. Now, when you get rid of that information, whether it's in hard file format and you're shredding it, or whether it's in a digital format and you erase or destroy it, you got to destroy it. And last but not least, you got to make sure everyone you share the information with does the same thing. Why? Because it doesn't matter to a victim of identity theft, to the person whose information was lost, where it was lost in this circle that every business has. The damage is the same to the victim no matter where it's lost. Now, here's another way to view the changed landscape. There are a number of laws that are separated by the legislative process, but not so cleanly separated in our day-to-day operation of medical practices or insurance agencies or other businesses. Authenticate the client, that's the red flags rule, or the employees' immigration laws. Keeping data secure, their state laws, their HIPAA, Gramm-Leach-Bliley, and various other laws, state and federal. Keeping the information private, obviously, with personal information like medical records, you got to have a permissible use to see them. The same thing with financial records. Then there are state and federal laws as well, the fact of document destruction rule concerning destroying it. The one that's red here is where everything has changed. Make sure everyone you share information with does the same thing. Because as I've already said, it doesn't matter to a victim where the information is lost or misused in this process. And that is what has changed. You are responsible not only for you safeguarding and securing all this information and keeping it private, but you're becoming responsible for your vendors, business associates, and subcontractors doing the same thing. The reason is very simple. In today's world, we have 5 common identity risks. You have a driver's license identity, a social security identity, medical identity. I hope you don't have a criminal identity. And then, last but not least, your financial identity. Your name and who you are is not how decisions are made about you. People make decisions about you, and you make decisions about others based on their social security numbers, driver's license numbers, and occasionally some other numbers like maybe their medical insurance or their credit card numbers. Because of this, it's imperative that personally identifiable information and non-public information, electronic health records, personal health records, those numbers be as protected and information as protected and accurate as possible. Once information is entered into a computer, it is backed up, copied, shared, transferred, or sold at least 1,000 times the first year. I recently talked with a client who had been stopped, and the officer told him he was going to give him a warning, clean cut, polite. He goes back and he pulls up his driver's record, and attached to it is an outstanding warrant for assaulting a police officer and for failure to show in court. Can you imagine how the circumstances changed? Well, I wish I could have told this person that we could get it straight, but you will never get those records straight. For the rest of his life, whenever he drives by an officer, fear will strike him. Do you think a jury is going to have any sympathy if that information came from your office or as a result of your not authenticating that your client was in fact who they said they were? When it costs almost nothing and you can stop most of this fraud, why wouldn't you? Just yesterday I read an article in insurancebroadcasting.com that said that the IRS had seen a staggering jump in identity theft in the past 24 months, up 5-fold. 5 years ago, medical identity theft virtually did not exist, but today we are hearing over and over again that incorrect and fraudulent information is being entered into databases, is being shared and reshared over and over again, never to be corrected. We see case after case. Imagine if that happened as a result of loss or misuse by some of your employees or your company, and you could never get it straight. I also read over 1.5 million people have already discovered their medical identity stolen, that the average losses were over $20,000 that they were aware of, and that 1 out of 2 almost had lost their insurance. Well, we could go on and on. I think you get the point that no one would have sympathy for someone who had not followed the law, especially when it didn't cost very much and it could ruin someone forever. With what I've just said in mind, here are the matters for consideration by everyone. There are mandatory breach notification laws and data security and privacy laws common in most states that require policies and training, and there are federal statutes and rules as well. When 1,000 plus records is involved, sometimes as little as 500 records, you must notify state and federal governmental bodies and the media. Now, imagine this. Let's forget about all the fines that you've heard about for violation of the red flags rule or violation of HIPAA, HITECH. Just the cost of notifying victims in a data breach from the loss of a laptop or thumb drive or hard files or something runs $100 to $300 per record. It is career ending for the person directly involved. This is much akin to a professional truck driver being convicted of a DWI or DUI. It's going to end the career of the person whose information is lost. There's a new trend, though, that the person at the top of the organization becomes personally liable for the cost associated with the loss if the loss is a result of failure in putting safeguards and training in place. And that can be not only for your organization, but to make sure that your vendors and business associates and subcontractors as well have these safeguards and security measures and policies in place. The person who sent you this video has a simple and non-business disruptive solution for you and your vendors. It's an online compliance training and documentation program. There's a simple online training for business owners, executives, and agents. And then there is a second training aimed at employees that will make them understand that if they mess up or lose someone's records, they could harm them for life. But also, under the new rules, that it could cost them their own job. And so whether or not they like working for you, they're likely to be more careful because it matters to them. It includes documentation and a lot of the new forms that are required, the breach notification plan, RFR policy if desired, the data transfer tracking form, and now you understand why there's a need for one, risk management analysis checklist, and many other documents. And this red flag and or HIPAA HITECH compliance program is available not only for your company, but for your clients, your business associates, and your vendors. Now, one of the other things this program does, is it will show you new products for individual clients and new products for commercial clients that you can provide to them. In other words, these new laws and liabilities could turn into a business explosion for you. Last, we want to thank you for your investment of time today. For watching this video, just contact the person who sent you this link and receive at no cost to you, first, a paper with guidance on how to determine which of your vendors must comply. Second, a list of 40 common vendors who must protect your information and, more importantly, maybe your client's information. Third, they will send you a list of Federal Registry sites and page numbers addressing the issues I've been talking about. And fourth, a template letter/email that you can send to your vendors and business associates to make sure your information is protected and your clients' is. Last but not least, they will send you a link for your company and an automated way to track whether your vendors have acted to protect your information and your client's information should you decide to proceed with our solution. So thank you for your time. Get back with the person who invited you to this recording, and I hope I get to meet with you or talk with you on some of our conference calls in the future.